very clear. We will not hesitate to take swift enforcement action using every legal tool that remains to us against any jurisdiction that seeks to take advantage of the Supreme Court's ruling by hindering eligible citizens' full and free exercise of the franchise.
As we continue to gather reaction to the Supreme Court's decision overturning a major enforcement mechanism of the landmark 1965 Voting Rights Act, leaving action up to Congress, we're joined by Tom Goldstein, a veteran Supreme Court lawyer and SCOTUS blog co-founder, and Sherilyn Ifill, president of the NAACP Legal Defense and Educational Fund. Sherilyn, I just was talking to Congressman Tom Lewis, who of course was with Dr. Martin Luther King Jr., and present when LBJ signed the bill into law in 1965, still has one of the pens. And he said that his message to the court would be, come walk in our shoes. You know, that you were not facing the dogs, and you were not facing the water hoses. And you don't know, you know, it took us 100 years to get that law passed. And he said that it was stabbing the Voting Rights Act in its very heart. Your reaction today?
Well, first of all, you know, that's a very eloquent statement by John Lewis, to which we all have to really pay attention. I mean, not only, you know, did the court not walk in the shoes that John Lewis walked in 50 years ago, but, you know, the court also is not walking in the shoes of our clients. The NAACP Legal Defense Fund represents black voters in Shelby County, Alabama. We were parties in this case. We argued this case in the Supreme Court. And our clients can well attest to the ongoing issue of racial discrimination in voting in their jurisdiction. In fact, Shelby County, Alabama was found by a court to have engaged in voting discrimination, you know, just in 2008. So this is not just about history. This is about the reality of today. It's the reality in towns and villages and counties all across the United States. What the Supreme Court did today, I think, was not only an act of judicial overreach, but it was a real betrayal of minority voters in this country, and it was a slap in the face to Congress, because Congress reauthorized the Voting Rights Act in 2006. They engaged in hearings over the course of nearly a year. They amassed a 15,000-page record. They looked rigorously not just at what happened in 1965 or 1975 or 1982 when the Voting Rights Act was reauthorized, but they looked at what had been happening in the covered jurisdictions under the Voting Rights Act up until 2006, and they determined that the act had to be reauthorized and that the coverage formula was appropriate to protect minority voting. The Supreme Court today has essentially thrown out the 15,000-page record that Congress amassed and has essentially said that 98 senators and 390 representatives in the House acted irrationally when they reauthorized the Voting Rights Act in 2006. It's a shocking decision. It's a disturbing decision. And now Congress has to act. And frankly, we have to act all over America to press Congress to return to the table and to restore the protections of Section 5 of the Voting Rights Act.
Tom Goldstein, Pete Williams was saying earlier that 4 years ago, the court basically warned Congress, you'd better get your act together and act on this. So there was plenty of lead up to this, was there not? And that Congress hadn't done anything, this very dysfunctional Congress in the last years and months in particular. So now, what is the rationale in Chief Justice Roberts' decision? And,
well, I think,
and Tom, and the counter argument by Ruth Bader Ginsburg, speaking for the minority.
It's true. Yeah, the Supreme Court did, by a wide majority several years ago, give this warning a shot across the bow of Congress. But civil rights advocates would say back that that was somewhat fake. The law still stood. It had been broadly reauthorized, and it's very hard for Congress to do anything, at least until its feet are put to the fire. The Chief Justice said today, we did warn you. We acted narrowly by giving you that advance warning about our serious concerns about the statute, and we've just decided that the country has changed enough that this formula, the original list of jurisdictions that are covered, needs to be narrowed materially. The dissenters were having none of that and explained that Congress, just as Ms. Ifill was explaining, had taken a very hard look at this question. They're the ones who are in the best position to make a judgment about where there is ongoing racial discrimination. But this is the divide in the Supreme Court. Those that are more suspicious of laws that are targeted at racial issues, more willing to give the states latitude versus a minority on the Supreme Court.
Sherilyn Ifill, we're understanding from our Senate team that Pat Leahy, the chair of the Judiciary Committee, is going to hold hearings this coming month and try to get something going. That's the Senate, of course, Democratic controlled, but very narrowly controlled, of course, and the House would be another matter. So what are your hopes of getting something through Congress?
Well, I have really high hopes. I mean, this is a place in which Congress really exercises the height of its power. And the framers of the 15th Amendment to the Constitution could not have been more clear that it's Congress and not the Supreme Court that has the authority to determine how best to enforce the ban against voting discrimination contained within the 15th Amendment. Now, the Supreme Court overreached today. They put themselves in a position above Congress by essentially saying, yes, you did all that work. Yes, you made a determination, but we don't agree with you. And Tom said it, you know, we think it's different, right? But the 15th Amendment says that's not the Supreme Court's place. But the Supreme Court speaks. It's the rule of law. That's what we follow in this country. And now Congress will have to do what it did in 1982 and what it did in 2006. And I should remind everyone that Congress was not, a body all hugging each other. Kumbaya in those days as well. There were many difficulties within Congress. We had, President Reagan sign the reauthorization of the Voting Rights Act. We had George W. Bush sign the reauthorization of the Voting Rights Act. This has always been a bipartisan piece of legislation. And the reason, Andrea, is because it embodies what we all aspire to in this country. It is a recognition of our highest democratic principles, the idea of equality, the idea of inclusion, the idea of ensuring that we don't make the victims of voting discrimination bear the burden of proving it. That's at the heart of what our country thinks about itself. You mentioned John Lewis at the top of the hour. We should remember that it was 49 years ago that Goodman, Cheney, and Schwerner disappeared when they went down to Mississippi to address the issue of voting rights. We should remember that it's the 50th anniversary in August of the March on Washington. This is a moment not for us to simply look back and commemorate those historic days, but recognize what it took for us to create the America that we all now enjoy and are proud of. And what it took was hard work. It took Congress stepping up to the plate. It took Americans of every race in every part of this country standing for the principle of equality. And that's what we're expecting from Americans and from Congress this summer and into the fall.
Thank you so much, Sherilyn. And Tom, just quickly, speaking of equal rights, and tomorrow we have two major cases to be heard from tomorrow. Is tomorrow the last day of the term? So we're going to hear about gay marriage tomorrow.
That's absolutely right. The court closes the door on a historic term with rulings on California's Proposition 8 and the Defense of Marriage Act tomorrow morning.
We will be there, and we will talk to you again. Tom, thank you very much. Sherilyn Ifill, thanks so much for today.